Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment. It was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
For decades, Indigenous rights in Canada were often treated by the Crown as revocable privileges rather than protected rights. But in 1982, Section 35 of the Constitution changed the landscape forever. It reads, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed." To guide us through this complex transformation, we are joined by 2 leading scholars. Together, we are examining the landmark decision of R. v. Sparrow from 1990, a ruling that shaped the modern legal relationship between the Crown and Indigenous peoples. Ronald Sparrow, a Musqueam band member, was charged under the Fisheries Act for fishing with a net longer than his band's license permitted. He did not deny using the net. Instead, he argued that he was exercising an inherent Aboriginal right to fish for food, a right that Parliament couldn't simply regulate out of existence. This was the first time the Supreme Court had to interpret Section 35. The court had to answer a fundamental question. Can the government still infringe upon Aboriginal rights? And if so, what strict tests must they pass to justify it? I'm Laurence Thériault, and let's find out in this episode.
Hi, I'm Professor Naiomi Metallic. I am Chancellor's Chair in Aboriginal Law and Policy at the Schulich School of Law at Dalhousie, and I am a member of the Listigoch Mi'kmaq First Nation.
Hi, I'm Karen Drake. I'm an associate professor at Osgoode Hall Law School, and I'm a member of the Wabigoon Lake Ojibwe Nation.
Welcome. Today we are looking at the big bang of Aboriginal law, R. v. Sparrow. But before we get to cast the net into the Fraser River, those who know will understand the pun, we need to understand the legal landscape of 1982. Professor Karen Drake, thank you for being with us today. Welcome.
Thanks so much for the invitation, Hugo.
Professor Naiomi Metallic, welcome to another episode of Shaping Canada. Before 1982, Indigenous rights were often seen as revocable. Can you briefly take us through the legal landscape from Confederation, so we're looking back at all the way down to 1867, up to Sparrow in 1990?
I mean, the history between Indigenous peoples and the Crown even goes back beyond before Confederation. We were in contact with each other and making treaties and relationships for the first 200 years, even before Confederation. But I won't go that far back in history, but I'll start around Confederation to say that some of the earliest cases we had recognized the inherent Aboriginal right and found that those rights were not affected by the common law. That's the case of Connolly versus Woolrich, a Quebec case from 1867. However, the sort of great step forward that might have been the promise of that case sort of got dashed when we get this decision from the Privy Council called St. Catherine's Milling in 1888, where, there was no Indigenous parties involved, but it was about, a transfer of lands from the federal government to a company, and the province of Ontario had an issue with that. But it was about Indigenous rights and about treaties involving Indigenous rights. But the court opine, among other things, around the nature of Aboriginal rights, essentially define them as revocable. It used this phrase as these rights are dependent on the goodwill of the sovereign. So it didn't see these rights as inherent, but only as given by the Crown. So Indigenous peoples really had no voice or say in that. And that sort of vision of Indigenous rights as essentially at the will of the Crown really lasted in Canada up until 1973, so almost 100 years later. And when we get the Calder case from 1973 involving land claim brought by the Nisga'a Nation to title to parts of British Columbia. It's a very important decision. And I should just mention, too, that the context leading up to this case was important. There had been a real sort of movement by Indigenous peoples. Indigenous peoples had always resisted colonialism. I think that's very important to say. But there was a particular resistance movement that happened after 1969 when the Trudeau government introduced the White Paper, which had purported to essentially erase all recognition of Indigenous peoples' treaty rights, get rid of the Indian Act, reserves. I mean, there's obviously problems with the Indian Act, but it was about eliminating the special relationship between Indigenous peoples and the Crown more broadly. And Indigenous people reacted very strongly, including pushing back against this proposal, as well as starting to go to the courts. And so the Calder case really, at the end of the day, recognized the possibility of Indigenous title existing and inherent rights existing beyond what was in the earlier St. Catherine Millings case. These were inherent rights. Now, on paper, it looks like the Nisga'a lost, but really it was a win because 6 judges held that, in fact, inherent rights did exist. However, there was a disagreement about whether these rights had been completely extinguished by laws about land and various other colonial laws that came after. And we can speak a little bit more about that later. And so this sort of opened the door for the recognition of inherent rights and sort of takes us then towards the repatriation of the Constitution.
I have in my notes regarding the Calder case, 1973, 6 of 7 judges agreed Aboriginal titles existed at common law. This panicked the federal government. So I understand that it was kind of a wake-up call, maybe? Is that the right way of saying it?
Yes. Maybe not panic. It changed the government's position. Up until that point, you know that the government of Canada stopped negotiating any types of treaties in 1926. After the decision in Calder, they decided to start negotiating land claims. And so that was a big step forward. And I think it perhaps made them afraid, but it also made them change their attitude and see that, things were changing.
You spoke about 1982, where the Constitution Act was signed. And right away, in 1984, the Guérin case, it's regarding reserve land, if I'm right. And that case has been seen as a kind of a double-edged sword. Can you explain why?
Sure. So this case was about Musqueam reserve land. The Crown has the responsibility under the Indian Act. First Nations wanted to lease it to a golf course. The Crown did that on their behalf. That's sort of a requirement under the Indian Act, except that they leased it on terms that the First Nation had not been aware of or not agreed to and wouldn't have agreed to. And so the whole question there was about if there was obligations beyond the Indian Act to really take into account the interests of the First Nations when they were acting on their behalf here. And as part of that, what's interesting and brings us back to Calder and the debate in Calder between the judges around, inherent existing rights to land and whether they had been extinguished. Effectively, the court agreed with the 3 judges who said they had not been extinguished. So they affirmed that part of the decision in Calder. So it was no longer a debate. Inherent rights existed. So that was very interesting. And as part of that, the court said that's where the fiduciary duty of the Crown to Indigenous peoples, it goes back to the special relationship that comes from things like the Royal Proclamation of 1763, and it also includes enforceable obligations. So a very good decision in these regards, but a bit of the problem, if I can try to explain it with it, is that the theory of inherent Aboriginal rights that the court sort of adopted, both in Calder and then affirmed in Guérin, comes from actually some case law from the United States from the mid-1820s and 1830s. They're referred to as the Marshall Trilogy, if anyone feels like looking that up. And the theory is that when colonists came to North America and quote-unquote discovered it, they said that did not have the effect of completely eliminating Indigenous people's rights, which on the one hand is a very good finding. But on the other hand, they said, but the fact of discovering this land, gave those crowns, those European nations, the control over the lands and the control over the people. That's what we call the doctrine of discovery. The fact that they discovered it gave them this, jurisdiction and power and the land, which, today we look at it and we say, well, that's a problem. What legal basis did they have to assert these things? And so this is the doctrine of discovery. And so, in fact, the theory of Aboriginal rights that got sort of floated in Calder, accepted in Garran, and then gets taken into the case law that we're about to talk about, including Sparrow, has as its foundation a recognition that these rights are impacted by the doctrine of discovery. And so that's a little bit of an issue that we may touch on some more as we go along.
So when we talk about the Crown, we've been talking about the Crown from the beginning. So we can presume it's the government.
Yes.
Okay. And now the fiduciary duty of the Crown or of government towards Indigenous peoples would be the obligation to represent in good faith their interest.
Good enough for today.
Now, as for the doctrine of discovery, Crown as ownership, Indigenous people only have occupancy. So they discovered it, but they can only occupy it.
That, and I would say all the control, all the legislative power and control is rested in the government.
And that doctrine of discovery, is it a little bit taken from St. Catherine's Milling in 1888, where the Crown basically owned the land and Indigenous people just have permission to use it? Is there a link between the two?
Yes, absolutely. They didn't use the term doctrine of discovery. It was so deeply embedded in their thinking that they didn't know how to describe it. They obviously assumed that the Crown had all the power. So they didn't even name it that, but that's essentially what it is.
Professor Drake, Section 35 of the Constitution Act, that very simply states the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So that Section 35 was drafted. There was a fight over the word existing, the existing Aboriginal rights of the Aboriginal people. So there was a fight over the word existing. Can you unpack that disconnect, or what did they mean when agreeing to that word? To me, Section 35, existing rights is very simple. These are the rights that existed before 1982.
There's a whole sort of drama around this issue. And I just want to cite my sources because in explaining this, I'm drawing from the case book from John Burroughs and Leonard Rotman. And this discussion is also set out in John Burroughs' book, Freedom and Indigenous Constitutionalism. So in the initial discussions about patriot in the Constitution, starting in the 1970s, Indigenous peoples were left out. There was no thought of giving constitutional protection to Indigenous rights initially. And so many Indigenous peoples were not supportive of patriation. And then this created public pressure to deal with Indigenous peoples' concerns. And so by the time we get to January of 1981, there is a draft provision that protects Aboriginal rights. And it's what you said, but with the word existing not there. Right? So that text that you described to us, but without that word existing.
So that would read simply, the Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed.
Exactly. So the drama continues. That's January. By the time we get to November of 1981, that provision was just dropped altogether from the draft constitution. So Indigenous peoples were shocked by this. Where did our provision go? So, and why did that happen? The answer is that there's pressure from the provinces to take it out, right? The provinces have the most to lose by constitutional protection for Aboriginal rights because Aboriginal rights primarily affect land, and it's the provinces who have title and jurisdiction to the land within provinces. And so they pressured the federal government to take that provision out. So then, in response, some Indigenous organizations engaged in political initiatives to have that protection for Aboriginal rights added back in to the constitutional text. So eventually, the provinces agreed to have the provision added back in, but the compromise was to add the word existing in as well. And the rationale of the provinces, primarily BC and Alberta, was that by putting this word in existing, they were satisfied that Section 35 would not be a threat to their interests. because they thought that the word existing meant, just as you said, rights that exist as of the date of the patriation of the Constitution. And their thinking was that there were no such Aboriginal rights because they'd all been extinguished by then. So to understand why they thought that, we have to go back to the Calder decision that Naiomi was just telling us about. So in Calder, Naiomi explained how 6 of the 7 judges agreed that Aboriginal title exists, but there's a disagreement about whether that had been extinguished. 3 said yes, it had been extinguished. 3 said no, it had not been extinguished. So there's Justice Judson writing for himself and 2 other judges who said that if there is some regulations that merely regulate how the land is used in a way that's inconsistent with the continued existence of Aboriginal title, that's enough to extinguish it. So the provinces were hoping that that's the test that would prevail. And if so, their thought was that all Aboriginal rights have been extinguished because they've all been regulated in such a way that the laws that exist in what's now Canada are inconsistent with the continued existence of Aboriginal rights and title.
This is very apropos, I would say, regarding Sparrow case, because when the court decided to interpret Section 35, they did specifically talk about the fact that most Aboriginal activities have been regulated, but there's a but, and we're going to explain it a little later in the decision. Professor Metallic, following Professor Drake's explanation of the inclusion of the word existing, did the province think it was going to be a political issue, or they said, oh, we're good, the court are going to interpret Section 35 the way we think it's going to go? Was that a political or a legal issue, the actual word existing in Section 35?
Well, what I can say is that the conversations happening around 1982 and around the sort of political back and forth between Indigenous peoples and the First Ministers at that time, because Indigenous peoples were actually raising, like, the statement of 35 is very, very sort of open-ended and broad. It's not very specific about what the rights were to be. And, if we're thinking about it as a box, we mentioned as a box, it's a wide open box. But the plan at the time and what Indigenous folks were told is, don't worry, we're going to have future constitutional conferences. And there were provisions in the Constitution that actually set timelines and committed the government to 2 more conferences with Indigenous peoples in order to flesh out what Section 35 was supposed to mean. But it didn't happen, or it was tried, but not much happened. So in 84, there were those meetings, but little happened during those. And in fact, if you're interested, there's a great National Film Board 2-part movie called Dancing Around the Table, Part 1 and 2. And that was a sort of phrase used by one of the Indigenous representatives. It's very interesting, but I think a lot of Indigenous people felt that they were just sort of dancing around the table, that there wasn't a lot of meaningful conversations happening. And then after that, of course, sort of not unknown to most Indigenous representatives, Canada was sort of having, side discussions with Quebec about addressing their concerns with the Constitution. And so then we get the Meech Lake Accord, which doesn't address any Indigenous issues whatsoever. I won't go into the whole history of that, but we know that Meech Lake did not happen, and part of it was owing to Indigenous advocacy. The MP, Elijah Harper, holding up an eagle feather kind of as a protest in the legislature to prevent the sort of discussion and the vote happening there, which led to other provinces not having their vote in the time frame given to make that happen, which then resulted later in the Charlottetown conversations, which were far more inclusive of Indigenous groups and would have sort of spelled out, in particular, rights of Indigenous peoples, primarily around self-government, but there were other provisions as well. So there was this fleshing out. But as we know, the Charlottetown Accord was put to a national referendum, and the national referendum vote was slightly more negative than positive. And so we didn't have that constitutional fleshing out of what's in the Section 35 box. So then it fell to the courts to interpret what Section 35 meant, which is going to take us to Sparrow.
So Ronald Sparrow is charged with fishing with a net that is too long. The case hits the Supreme Court in 1990. I found a publication from the Library of Parliament that introduces R.V. Sparrow. The Supreme Court of Canada considered for the first time the scope of Section 35(1) of the Constitution Act of 1982, which recognizes and affirms the Aboriginal and treaty rights of the Indigenous peoples of Canada. Professor Drake, legal scholars like Darling Johnston argue that Sparrow was actually the high watermark of Section 35 jurisprudence, that it was the best it ever got. Why is that? Why Professor Johnston says this? And let's remind our listeners that Sparrow is a 1990 case.
I just want to give everyone a little bit more context for this. The reason why I'm so happy to talk about Professor Johnston's analysis of Sparrow is because it gives me a chance to think back to my time in law school, and I learned this jurisprudence from Professor Darlene Johnston. I was in law school, this is back in the early 2000s, so if anyone disagrees with Professor Johnston's analysis, it's not because she's missed out on 20 years of jurisprudence. If I'm accurate in my memory from that law school experience, there's a couple of reasons for giving us this take. So one reason why we can think of Sparrow as the high watermark of Section 35 jurisprudence is because if you think about the first step in the test that Sparrow sets out, the first step is establishing the right. Is there an Aboriginal right here? Well, in Sparrow, in order to answer that question, all we have to do is look to the laws of the Indigenous people themselves. That's what the court does in Sparrow. They just look at the laws of the Musqueam people and they ask, well, do their laws allow them to do this thing they want to do, to fish with this kind of net? And if they do, then yes, there's the right. It's established. Now, in the very next decision in Vanderpeet, the court acts like Sparrow never happened. And they set out an entirely different test for establishing the right. And the new test in Vanderpeet is much narrower, it's much more restrictive, and therefore it's much more difficult for Indigenous peoples to meet that Vanderpeet test. So that's the first reason. The second reason I think that Professor Johnston perhaps had in mind is because even though Sparrow establishes a test, and here I'm thinking about the fourth step in this four-part test, so it's a justification test, and it allows governments to justify their infringement, or in other words, their violation of an Aboriginal right. So even though Sparrow does that, when it explains what that justification test is, it's actually very difficult for Canadian governments to meet that justification test the way that Sparrow articulates it. And what I mean by that is that the kinds of legislative objectives that will satisfy the test, the way it's explained in Sparrow, they're very narrow. But then in later decisions, those objectives get expanded, right? There's a lot more room for governments to justify their infringements. Also in Sparrow, as part of this justification test, there's a requirement to give priority to the Aboriginal right. But in later decisions, that test gets reframed into more of just a balancing, which is indistinguishable from the Oakes balancing test. That's very different from having a requirement to give priority to the Aboriginal right over any other interests in the resource.
Lots to unpack. You did say that in order to see if there's an Aboriginal rights, we need to check the laws or the customs of the Aboriginal peoples. I believe that in Sparrow, they used anthropological evidence from Professor Dr. Wayne Suttles in order to establish for the Aboriginal peoples that, yes, we had the right to fish in that particular river from, by the way, it's mentioned in Sparrow, from times immemorial. So did this evidence regarding the Musqueam bond with salmon change the game compared to how courts usually look at evidence? Basically, the first part of the test is to establish that there is a right, and the onus falls on the persons, the Aboriginal group, that says there was a right. Doesn't have to be a treaty. There was a right, and we've had it. And how do you make that proof? They decided to use Dr. Suttle's anthropological findings, correct?
Yeah, exactly. And just to give a sense of how significant this is, I want to read the actual passage that the Supreme Court quotes that summarizes the evidence of Dr. Suttles. what they say is that the salmon was not only an important source of food, but played an important part in the system of beliefs of the Salish people, which includes the Musqueam, and in their ceremonies. The salmon were held to be a race of beings that had in myth times established a bond with human beings, requiring the salmon to come each year to give their bodies to the humans, who in turn treated them with respect, shown by performance of the proper ritual. Toward the salmon, as toward other creatures, there was an attitude of caution and respect, which resulted in effective conservation of the various species. There is so much to unpack from this. So the quotation is talking about a bond between the salmon and the humans. And I can't purport to analyze the laws of the Salish people, which, as I said, includes the Musqueam. But so much of what is said here is analogous and consistent with my understanding of Anishinaabe law and Anishinaabe constitutionalism. So I'm going to say a little bit about my understanding of that. I just want to be careful not to purport to be able to analyze the laws of a people whose laws I don't have familiarity with, but I have some sense of Anishinaabe laws. So when I hear language like bond, to me, from an Anishinaabe perspective, this is a treaty. And having a treaty with animal nations is very common within Anishinaabe life worlds and Anishinaabe constitutionalism. And when I see salmon being described as a race, to me, this is very similar to Anishinaabe notion of different animal nations, and that we can have treaties with those animal nations. And when I see this language of salmon giving themselves to the humans who treat them with respect, to me, that's very consistent with Anishinaabe notion that all aspects of the natural world, including animals, have agency. In other words, they are members of our community. They're not objects. They're not resources. They are our relations who we are in a treaty relationship with. And when we hold up our end of the treaty, they hold up theirs. Right? So when we give them the respect that the treaty requires, then they make a decision using their agency to give themselves to us to help to satisfy our needs. And so this is just an articulation of, or it could be, again, I don't want to purport to analyze Musqueam law, but it could be just an articulation of Indigenous law. And this was enough. This was enough in this decision to establish that the Musqueam have this right to fish for the salmon, merely describing their laws that allow them to do that. Now, you said, did this change, the way the court views evidence? I wish it had. Unfortunately, as I mentioned, this didn't stick. Right? In the very next decision in Vanderpeet, the court sets out a new test, and they don't use this same approach, unfortunately.
They're not using the same approach in Vanderpeet. Is it because, and maybe I'm completely out on left field right now, but it was not really an issue for the Supreme Court, the right of the peoples to fish in that particular river. It was not denied by the Crown or the appellants at the time. Could this be a reason that, it's kind of like established that the right exists?
That is the reason that the court gives in Vanderpeet, right? That's what they say. I would challenge that a little. It's true that it wasn't contested in the lower courts. And so, yes, especially if it's not contested at trial, there is something to that. But if I recall correctly, I believe that the Crown did contest the existence of the right at the Supreme Court. And so there was some actual examination of whether the right is established in Sparrow. And in fact, in Sparrow, the court made the point that the evidence that was put forward was scanty, and yet it was enough. Right? That was enough. It wasn't a high threshold that had to be met.
So they did contest it, but from what I understand, it was more of one of the arguments that they stated at the Supreme Court. However, the court was very, very adamant to the fact that the Crown, the respondent's argument, confuses regulation with extinguishment, and that they did not need to make the proof that they were fishing from times immemorial.
So I would say that it was a live issue, right? So it was a live issue at the Supreme Court, even if it wasn't at the lower courts, whether the right was established. And that's why the court quotes the evidence from Dr. Suttles And the court even acknowledges that the evidence wasn't extensive, but it was sufficient.
Professor Metallic, while they recognized the right to fish, the court also created a mechanism to limit it. Can you walk us through the justification test they invented?
I think a good starting point to this is to first say that Section 35 sits in Part 2 of the Constitution Act 1982. Part 1 is the Charter. So they're in different sections. And the first section of the first part of the Charter is Section 1, as many of us in the legal field know, which speaks to reasonable justifications. And the court developed a test about when governments can reasonably infringe on charter rights. And that's taken on the shorthand of Oakes, the Oakes test. It was developed in a case called R versus Oakes. So, as was noted just now with Professor Drake, on the right itself was largely taken as a given, and moved forward, the court developed these sort of other aspects of what comes to be known as the Sparrow test, extinguishment, and then infringement and justification. I know we're going to talk about extinguishment a bit after. So, the argument of Mr. Sparrow and the Musqueam was there's a recognition of the right, but they weren't trying to argue that it was an absolute right. In fact, they did acknowledge that there potentially could be some narrow grounds for limitations and having to do with safety issues, so I'm not practicing one's rights in unsafe ways that would cause harm to the person themselves or other Indigenous people or non-Indigenous peoples as well. But the court didn't accept that and sort of framed it as if they were making an argument for absolute rights with no protection, with no limits. And the court says, no, we need something else. And because there is no Section 1 and Part 2 of the Constitution Act, they turned to the language of recognized and affirmed in the actual language of Section 35.1.
So Section 35.1 actually says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So they're using this wording in order to justify the justification test.
This is it, exactly. And so it's an interesting conversation because here the court actually talks about sort of the history of denial of Indigenous peoples' rights. And they say that Section 35 is sort of a game changer in that regard. And so they talk about the history of denial, and that Section 35, one of the reasons it came about was as a mechanism for just resolution of Indigenous peoples' claims. And there's even a part where they quote with authority or with approval Professor Leon. I believe he was a professor at McGill around the time, but he in a paper had discussed how, Section 35, and they quote this with approval, renounces the old rules of the game where the Crown established courts and denied the courts the ability to question sovereign claims by the Crown. And so there was a recognition on the one hand that this was a game changer and was changing things, but on the other hand, they also sort of started that section with this really kind of somewhat head-scratching quote that kind of is inconsistent with what I just read you, which was that the sovereignty of the Crown was never in doubt. So on the one hand, they say Section 35 is a game changer and allows us to question the sovereignty of the Crown. They start that section by saying, but the sovereignty of the Crown was never in doubt. So that's a little bit of a head-scratcher, and I think one of the things that has sort of bogged down this area of law. And on the one hand, the court says, okay, there's the Crown sovereignty never in doubt. So they turn to Section 9124 of the Constitution Act 1867, which recognizes the legislative jurisdiction of the federal government over, quote, Indians and lands reserved for the Indians.
So in the Constitution of 1867, there are two subsections, that deal with who from the provinces or the federal government can legislate on certain aspect of civil law, of Canadian way of life. Best example I can give you, health and education is a provincial power. However, the Army is a federal power. But 9124 does say that the management, for lack of a better word, of our Aboriginal affairs, were called Indians at the time, is under the jurisdiction of the federal government.
That's right. And so the court sort of took that as their starting point and saw that as a very broad power. Again, going back to this idea that the Crown has very broad power over Indigenous peoples and their lands. And so they start there and they say, but we have this. And then on the other hand, we have 35, which is supposed to be a bit of a game changer. So they kind of meet in between. They sort of say, okay, so there's the power for the government to pass laws that are going to impact on these rights, but Section 35 creates some limits on that power. So that's how they sort of square them, and that's how they read, recognize, and affirm. And I should say, too, they go back to this concept of a fiduciary relationship. Remember when we talked about Guerin? They pull that concept in here, and they say, and so when the government has an obligation, or when the government is going to limit, they have obligations, and Karen sort of listed some of those. And it looks a lot like the Oakes test, that they have to meet an objective. They have to have a substantial objective. And then the second part asks whether they have met their relationship or fiduciary obligation. So the court sort of speaks to the need to give priority, in that case, to the Aboriginal right in question. And then other things to look at would be whether there's been compensation, if there's been any expropriation of a right, whether there has been consultation. And so those are the things that need to be looked at in addition to the government having an objective. And so I think I would largely agree with Karen on her point that the test as articulated in Sparrow was framed as nonetheless still a high bar. Let's say at least the objectives that are mentioned are safety and the conservation, but they also say conservation and management of the resource. So some people have said that has the possibility to be kind of broad if you start unpacking it.
Professor Drake, with what Professor Metallic just explained to us regarding the justification test and the words recognized and affirmed, was the word existing necessary because the words recognized and affirmed were always there?
Yeah, so this gives us a chance to come to the conclusion of the drama that we started to look at earlier, right? So were the provinces right by adding in the word existing? Did it give them what they thought it did? Did it mean that all Aboriginal rights were already extinguished by 1982? And Sparrow finally answers that question. And it turns out that the provinces were not right. So Sparrow doesn't affirm Justice Judson's approach. And we already got a spoiler to that in that regard, because Naiomi told us that in Guerin, Justice Judson's approach wasn't affirmed. And so then Sparrow again just, confirms that. It's actually Justice Hall's approach and the two other judges that he was writing with. So what Justice Hall said was that in order for an Aboriginal right to be extinguished, the sovereign's intention, so the government's intention, must be clear and plain. And what that means is that mere regulation is not sufficient to extinguish the right. So just because a right is controlled in great detail by regulations, it doesn't mean that the right's extinguished. So even if there's legislation and regulations that are inconsistent with the continued existence of the right is not thereby extinguished. And so in Sparrow, the court concluded that there was nothing in the Fisheries Act or its regulations that demonstrated that clear and plain intention, right? That said something to the effect of the right is hereby extinguished. Nothing said that. And so the right was not extinguished.
If we transpose what you just said to the Sparrow facts, Mr. Sparrow was caught fishing with a net that was longer than what the permit basically granted by the province told him. So it was supposed to be 25 fathom, and I think he was fishing with something that was 35 fathom. Basically, the argument was because we started regulating on the fishing rights of the Aboriginal peoples, those rights are extinguished. And basically what the Supreme Court is still telling us is that it's not because you are making some rules and regulations around a practice, it doesn't mean that we've extinguished the right.
Exactly.
Is there a test regarding this, or it's just the Aboriginal peoples that have to demonstrate that they have right that is ancestral, that is cultural, that is part of their law, like you said a little earlier. And once they've established this, they can sit down. They've made their proof. We have a right and you cannot infringe on it, government. Now, government, tell us why you're allowed to infringe on that right. Correct?
So you're missing a step there. So the first step is establishment, like you said. So establish the right exists. The second step is extinguishment. So extinguishment is still possible. It's just that it's a higher test than what the provinces had hoped. It's a higher test than what Justice Judson and Calder had explained. The test is one set out by Justice Hall in the Calder decision, and it calls for the government to show that they exhibited a clear and plain intention to extinguish the right. And the example that Justice Hall gives in the Calder decision of like, what would that look like? Basically, what he says is you would use language to the effect of the right, whatever it is, the Aboriginal right to title, is hereby extinguished. That's what a clear and plain intention looks like. So merely saying how the right can be used or exercised, that's not clear and plain.
So after 1990, did the provinces go, we missed one? We should have extinguished all the rights, and maybe in just one document says all Aboriginal rights are hereby extinguished?
Perhaps, yeah. I wasn't there, but that seems logical.
Well, they still make the arguments, right? They'll still try to argue in all kinds of cases that there's extinguishment, because what the court said after entrenchment, the argument cannot be made of anything extinguishing after 1982 without the consent of Indigenous peoples. But before that, they can point to legislation or other things. There's a little bit of wiggle room in the case law. Like I think it's in Gladstone or somewhere where the court said something to the effect of it doesn't necessarily have to be like perfect language or a magic incantation. And so there's a little bit of room to try to argue it can happen somewhat more implicitly.
Yeah, no, absolutely. Thank you, Naiomi. In Gladstone, I think the word they use is it does not have to be explicit, right? Which suggests it could somehow be implicit. And there are examples where governments have won on this point. I think it's Horseman, where the right was extinguished to a small extent. But it is rare. But it's possible for governments to win on this point to show that a right was extinguished before 1982. That's the one example I know of, though, the Horseman one, I believe.
I'd like to go back because it seems to be like a small case, like somebody that has a net that is too long. In order to make such an important interpretation of Section 35.1, was it the right case at the right time to interpret for the first time Section 35.1?
I think it's just the nature of test cases. If you think about, do we want something grander, more significant? How can we imagine Indigenous peoples just going around exercising full self-government, right? So I think it's just the nature of how test cases work.
I mean, I guess I would say, too, that in some ways it was the good case to go forward, because we see in future cases the court gets more limited in its approach, and those are cases that introduce commercial dimensions to rights. I guess what I'm saying is like this test case about fishing for subsistence being the first one to come forward was probably one of the best cases to come forward with, because it did not introduce, I think, perhaps, at least in the eyes of some of the judges, the complexities that gave them concerns, self-government, gambling, commercial rights, that I would say led in future cases to a winnowing down of the protections.
So the court does say, while the trial for a violation of a penal prohibition may not be the most appropriate setting in which to determine the existence of an Aboriginal right. So, yeah. Professor Metallic, now that you've heard Professor Drake on the extinguishment, do you have any further thoughts?
Yeah, I think it's a really important area to talk about. I think we sometimes think, well, the court set the bar pretty high on what constitutes extinguishment, so it's not a concern. But let's just think about this in a different way. I think it takes us back to this idea of revocable rights. Essentially, that's what extinguishment is. It is the elimination, the revocation of rights at the will of the sovereign. And let's think about charter rights. Can you think of any charter rights that can be extinguished? No, you wouldn't be able to, because we don't think about fundamental human rights as being able to be extinguished. And I think that's a problem, and where the UN Declaration on the Rights of Indigenous Peoples, and it introducing the fact that Indigenous peoples have these fundamental human rights is important in sort of the evolution of our thinking, because I don't think that early on we really saw them in that same light as individual charter rights, but now they have been confirmed as collective rights, but nonetheless fundamental human rights. And there's documentation and reports by UN bodies that say that you cannot extinguish fundamental rights, and Indigenous rights should not be seen as being able to be extinguished by governments.
Professors, in all my episodes, I like to talk about the impact, the legacy, the evolution of the decision we talk. Today we have Sparrow. Professor Drake, earlier you mentioned that Darlene Johnston, known scholar, argued that Sparrow was the high watermark. Now, does it mean that it can only go downhill from there? And is Vanderpeet one of the possible decline from Sparrow? And can you maybe enlighten us a little bit on that decision? Vanderpeet, which is a woman named Dorothy Vanderpeet, a member of the Stolo Nation, was charged with illegally selling fish.
Yeah, exactly, Hugo. I think that's what Professor Johnston meant. She was talking about the Vanderpeet as being one of these examples of the decline. And so in Vanderpeet, we find out that there is a new test for whether the right has been established. And in order for there to be an Aboriginal right now, according to Vanderpeet, there has to be some activity that's an element of a practice, custom, or tradition that is integral to the distinctive culture of the Aboriginal people claiming the right prior to contact with Europeans. Okay, there is so much to unpack. Basically, what this does is it makes the right so much narrower. It makes the test so much more difficult to meet. It's a very high threshold.
When you read those additional questions, it does talk about the central significance of the practice, custom, or tradition. So it's even to me, the way I'm reading it, like kind of even a higher test than just establishing that there was a practice, custom, or tradition.
So yeah, what does it mean for it to be integral? The court in Vanderpeet says it has to be of central significance, just like you said, Hugo. And that also means that it has to be of independent significance to the Aboriginal people, and it cannot be incidental. And this was precisely the reason why Ms. Vanderpeet lost in this case. So in terms of when the court was applying this test, they looked to see what the evidence was, and no one disagreed that there was evidence of the Stolo people exchanging fish for money or other goods. Everyone agreed that, including the Crown's own expert witnesses, right? That there is evidence that this was happening prior to European contact. So even meeting that really high threshold of having to go back in time that long. However, Ms. Vanderpeet still lost, even though there's evidence that the Stolo people are doing the thing.
Because it was incidental.
Exactly. The court said that what was of central significance was fishing for food, but exchanging it for money or other goods was just incidental to that. They did it. Their own laws allowed them to do it, right? The fact that they did it means that their own laws permit them to do it. But it wasn't central enough. It wasn't significant enough, according to the court's analysis.
But in Vanderpeet, the majority of the justices of the Supreme Court of Canada highlighted several guiding factors that a court must consider in its assessment of Aboriginal rights, including the central significance of the practice, custom, or tradition to the Indigenous society in question, but there's also including, so it's not limited, but to the perspective of Indigenous peoples themselves, the precise nature of the claim being made, the relationship of Indigenous peoples to the land, and the distinctive societies and cultures of Indigenous peoples. Professor Metallic?
Whenever I have to read it, and I usually have to reread it every year, it gets worse upon rereading every year, especially in terms of where we're coming to now. And I think I come back to my point about the UN Declaration on the Rights of Indigenous Peoples and what it tells us about the nature of these rights. And I even think the fundamental starting point of where Lemaire started in Vanderpeet was just the wrong starting point in terms of where we are today. You know, he starts off by noting that Indigenous rights, collective rights, are different from charter rights. Those are universal rights. These are not. And therefore, he pulls from that they have to be defined narrowly. They have to be very specific, and imposes this high burden of proof, which doesn't exist for charter rights. For a charter right to establish, a breach of Section 2A or B, all you have to do is prove a prima facie case. Enough evidence to show that it is right. Maybe the way they sort of implicitly did it in Sparrow, as Karen was talking about, more of a prima facie case. But now the court imposed, in fact, in every case, every group, the requirement to have to show this integrality to a past practice or custom. And so it's a very, very difficult test. They were not seeing these as fundamental human rights. They were seeing them as something different. And because of that, special rights, they were to be limited. And they only based the reason for there being these rights, the purpose of it, as only based in the fact that Indigenous people were here first. But that's one reason, prior occupation, to recognize our rights, but it's not the only reason. The history and our role in this country and taking care of the land, and also the fact that our rights have gone without being recognized for such a long period of time. Anyway, there's a lot more that the court could have thought about in sort of setting out this test.
Professor Metallic, when you mention prima facie, it's a Latin term meaning at first sight or at first look. So it refers to a standard of proof under which the party that has the burden of proof only need to present enough evidence to create a presumption.
Absolutely. That's perfect.
Every year you reread that decision and you're more critical of it. Do you think that today's eyes, the court would have rendered a different decision in Vanderpeek and maybe in Sparrow? And related to this, do you think that Sparrow basically opened the door to help the government to infringe on Aboriginal rights?
I think so, because so much of the emphasis, unfortunately, in Sparrow, so much of the focus is on this justification test. And there's a colleague of ours, Brenda Gunn, and she's written about sort of comparing the international law approach to how the court sort of just put so much emphasis on justification that it seems to have left governments with this sort of, infringe first, see if they sue you sort of attitude, right? Not that we have to start from protection and respecting and using our jurisdictional powers and other powers to recognize these rights. And because the infringement and justification test broadened over time, I think that that's sort of fed into it. And I also think, I mentioned earlier the sort of political unwillingness to really advance, recognize Aboriginal rights. I would say in the same way as we see with charter rights, there is more of a culture of respect for charter rights. You can point to counter examples, I'm certain, and we still have charter cases. But the same sort of level of respect, or governments feeling they have an obligation to recognize and promote, it seems like it's far less. And I think Sparrow may have had a role to play in how much that, and in future similar cases involving the justification framework, it kind of sent the message, infringe first. You can probably justify it if they can afford to take you to court. But here's the funny thing. One more thing I'll say. Because of the Vanderpeek test and how hard it is to prove a right, we barely ever get to cases where the government actually can justifiably infringe, because the test has been made so hard that groups mostly fail on the first part and never even get to make the arguments that the government unjustifiably infringed.
Professor Drake, if I would ask you then, is Sparrow strong enough to carry us in the future? Could we go back to Sparrow and try to, move past Gladstone, Vanderpeek, and say we had it right at Sparrow?
Yeah, great question, Hugo. I maybe wouldn't quite use the language of going back to Sparrow, because there is a trend happening that is adopting that approach in Sparrow, but without acknowledging that that's what's happening. And so what I have in mind here is the Montour decision. So this is a decision from the Quebec Superior Court. And what they say, we're not going to use the Vanderpeek test. And the UN Declaration on the Rights of Indigenous Peoples is one of their rationales for doing that, right? So they say we're going to develop a different test altogether for establishing the right. And the test that they come up with is essentially what was happening in Sparrow, although they don't quite say that, right? They basically just say, what is the collective right that's being asserted? And is it protected by the legal system of the Indigenous peoples? And is the thing that the Indigenous people want to do, is it an activity that falls within that? In a way, that's drawn from Sparrow, but the UN Declaration is a big part of it.
Is this now the tool that we need to fix the cracks from the Sparrow decision?
I actually think it is. And I just want to quote the Truth and Reconciliation Commission, who one of their recommendations was that the UN Declaration can be the framework for reconciliation. Like Karen, I do think that there are some actually quite good aspects of Sparrow. The purpose that was discussed in Sparrow about what Section 35 was trying to do, change the rules of the game, lead to just resolution. That's really good stuff, and it's better than what, kind of got changed in Vanderpeet. And I think you can use the UN Declaration to think through some of the weaknesses of Sparrow that we have been touching on. The UN Declaration does include one provision, Article 46.2, which does contemplate some limitations on the rights in the instrument. However, it's much narrower than even Sparrow, or where Sparrow eventually got taken up by other cases and made more broad. My reading of it, it seems to focus us on only things that are, the most just and necessary, and it's about other infringements of other fundamental human rights. And it would be to that level, not just other people's interests in the resource and management and sort of these broader things. So I think that it can help us in that way. And I think, even the statement of the purpose of Section 35 in Sparrow, the UN Declaration fits into it because it helps. It's an instrument that is also itself trying to address the harms of the past, even at the international level, including the doctrine of discovery, where that initially came from. So there's a lot of synergy or symbiosis that can happen between the test and Sparrow. But I also think UNDRIP makes a huge emphasis on consent as well. So I don't want to leave this by suggesting that, the UN Declaration allows limitations, and so go ahead, governments, limit those rights. UNDRIP also puts a massive emphasis on free, prior, and informed consent and self-determination and respecting collective rights of Indigenous peoples to their autonomy and to participate in decision-making more broadly in the nation state. So all of this, I think, requires, in many cases, consent, and that fallback of a potential limitation is far more narrow than Sparrow. But I think it's still nonetheless can work with some of the Sparrow foundation.
I'm going to read from the Sparrow decision that says, it is worth recalling that while British policy towards the native population was based on respect for their right to occupy their traditional lands, a proposition to which the Royal Proclamation of 1763 bears witness, there was from the outset never any doubt that sovereignty and legislative power, and indeed underlying title to such land, vested in the Crown. So, Professor Metallic, Sparrow rejects the old colonial rules, but still accepts Crown sovereignty without question. Is this the original sin of the decision? And if you would rewrite part of Sparrow, which part would you delete? Which part would you change?
Yeah, the sort of this preoccupation with sovereignty and the sovereignty without a doubt. I think that's part of it, right? And that's what leads, I think, to the justification test that just gets broader and broader as the case law goes along. And so it goes back to this idea of the revocableness of the rights, of the Crown having all the control. And so that idea, too, is all inconsistent with the UN Declaration on the Rights of Indigenous Peoples, right? Seeing these rights as fundamental human rights. And also coming back to this doctrine of discovery and how it is still embedded in this concept of Crown sovereignty that is within Sparrow. Preamble 4 of the Declaration says that all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. The Canadian legislation implementing the UN Declaration uses that similar language in a preamble paragraph, but it also identifies that one of those unjust theories is the doctrine of discovery. So it's about sort of taking that out and seeing how that idea has influenced the case law and fixing that. And I think the UN Declaration can assist. And it goes back to my earlier answer of seeing the relationship more as one of nation to nation, consent being a much bigger part of it. Perhaps there can be some limits, but very limited limits. And I think consistent with UNDRIP, those would be based on impacts on other people's fundamental human rights and only in the most just and necessary situations.
What would you change in Sparrow?
I would bring in the international law and international instruments to help us think about what is a just and fair relationship. I think there is still some possibility for some limited justification. However, it has to be more narrow. So I would narrow down that part. I would get rid of extinguishment. That is gone because that is fundamentally not consistent with international human rights. And I think that's a good start.
Professor Naiomi Metallic, Chancellor's Chair in Aboriginal Law and Policy at the Schulich School of Law at Dalhousie University. Thank you so much for your time and expertise today.
You're very welcome. Thank you for having us.
Professor Karen Drake, Associate Professor at Osgoode Hall Law School. Your work on Anishinaabe constitutionalism and the complex interplay between Indigenous and state law was invaluable to this conversation. Thank you for sharing your insights with us.
Oh, it's my pleasure. Thank you again for the invitation, Hugo.
Thank you. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Kazirer, Suzanne Côté, Andromaki Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naiomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Backen, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.